Welcome to the deep dive. We tackle dense sources. Today it's complex tort law cases, and we pull out the actionable insights for you. Today we're asking, when is an accident legally just an accident? We're looking at how the law decides if someone who caused harm gets excused because they were in sudden emergency, that common plea, I couldn't help it. But, well, courts seem really hesitant to buy it. We're digging into the sources around a key case, Posas v. Horton.
That's exactly right. The standard of care, the baseline is always what a reasonably prudent person would do. The sudden emergency doctrine, it's basically a jury instruction that says, okay, let's temporarily lower that standard a bit, acknowledging that people panic under extreme stress. So to really get it, we need to outline the strict requirements, look hard at Posas v. Horton and the cases it leaned on, and then pull it all together into a usable framework. And this involves paying close attention to legal policy, and really understanding the difference between just, normal traffic headaches and a genuine, out-of-the-blue emergency.
Okay, let's get into it. So, if you want this defense, the very first thing, the biggest hurdle, seems to be proving you didn't cause the mess yourself. How does the law make sure the person claiming emergency wasn't just, dealing with the results of their own bad driving?
Yeah, that's the first critical filter. And honestly, it sinks the defense most of the time. The general rule is crystal clear. To even get the instruction considered, you have to show solid evidence you were put in danger through no negligence of your own. You absolutely must prove you were driving like a reasonably prudent person before the whole emergency situation popped up. Think of it like this. The restatement of torts puts it plainly. Even if you react perfectly after the emergency hits, that doesn't wipe away liability for the bad driving that created the emergency. So prior fault. It kills the instruction right there.
Seems pretty strict. Okay, let's test that right away with the facts in Posas v. Horton. So Amelia Posas is driving. Suddenly, a woman pushing a stroller jaywalks. Posas has to slam on her brakes. Nicole Horton, driving right behind Posas, smacks into her. Now, here are the really crucial details. Horton's going maybe 10 to 15 miles per hour, but she's only, get this, 3 to 4 feet behind Posas. 3 to 4 feet. And incredibly, she actually admitted it on the stand. She said, and I quote, "Yeah, obviously I was following too close. I rear-ended her. I made a mistake." Wait, 3 to 4 feet at 15 miles per hour? I mean, that's basically touching bumpers. Given that, let's analyze Posas v. Horton. First, what are the legally dispositive facts?
The key facts are pretty straightforward. Posas stops fast for a jaywalker. Horton hits her from behind. Why? Because Horton was only 3 to 4 feet back, going 10, 15 miles per hour. And crucially, Horton admitted she was following too close. Despite that admission, the trial court gave the sudden emergency instruction, and the jury found for Horton.
Okay. And what was the core legal issue the higher court had to decide?
The big question for the Nevada Supreme Court was this. Did the trial court mess up by giving that sudden emergency instruction when Horton, the defendant, had basically already confessed to being negligent by falling way too close?
Makes sense. What rule did the court use to figure that out?
The court really hammered home the rule. The doctrine only applies if the person proves they were otherwise exercising due care, meaning not negligent beforehand, and were suddenly put in danger through no fault of their own. The instruction is only for situations where unexpected stuff happens to someone who was, up to that point, driving reasonably.
So what was the court's analysis based on that rule?
Well, the analysis really hinged entirely on Horton's own testimony. Her saying I was following too close was basically Exhibit A, that she wasn't exercising reasonable care before the jaywalker appeared. By tailgating like that, she put herself in a position where she absolutely could not stop safely if the car ahead stopped suddenly. She created her own inability to cope. So she produced her own peril, therefore the instruction just wasn't appropriate.
And the final conclusion from the Nevada Supreme Court.
They reversed the judgment. They found the trial court abused its discretion by giving the instruction. And it wasn't a harmless error either. Giving the jury that unwarranted out, despite her admission, very likely swayed the verdict. It was prejudicial.
Wow. Okay, so that prior negligence rule is a really strong gatekeeper. If you messed up at all before the incident, you're probably out. But what about the emergency itself? Does any surprise count? And who exactly needs to be facing the emergency?
Right. That takes us to the second big requirement, foreseeability, and who the emergency actually affects the proper actor. The general rule here is that the emergency has to be a sudden and genuinely unforeseeable change in conditions. The law basically says, look, driving today involves chaos. You have to be ready for routine hazards. Things like sudden stops, cars merging unexpectedly, pedestrians stepping out. Legally, those aren't treated as unforeseeable emergencies. They're part of the territory. And critically, The emergency has to be something that directly impacts the person asking for the instruction.
Okay, so we need to draw a line between just, everyday road chaos and a real emergency. The Posas court specifically looked at other cases to help draw this line, right? Like Templeton v. Smith. We need to understand what courts expect us to anticipate constantly. Let's dig into that analysis adopted from Templeton v. Smith. First, what were the key facts there?
Okay, Templeton. The defendant is following the plaintiff. She glances in her rearview mirror for just a moment. When she looks back, bam! The plaintiff's car is stopped unexpectedly. She couldn't avoid hitting them. And just like in Posas, the jury got the sudden emergency instruction and found for the defendant driver who did the rear-ending.
And the core legal issue in Templeton?
It was whether that momentary glance away or just the fact that the lead car stopped quicker than expected actually qualifies as an emergency that justifies the instruction.
What rule did that court apply?
Well, the Templeton court reasoned that some things that feel like emergencies are actually things drivers should anticipate. They cited other cases like Gagnon and said the event has to be truly extraordinary. They gave examples of what's not extraordinary and therefore must be anticipated. Kids running out, busy intersections, sudden stops, obstacles appearing, ordinary hazards. They contrasted that with real extraordinary examples like a truck careening out of control or a sudden mechanical failure, something truly bizarre.
Okay, so how did the court apply that rule in its analysis?
The court basically said that the car in front stopping sooner than expected. That's exactly the kind of thing you have to anticipate in normal driving. It's routine. The defendant in Templeton, they said, wasn't facing anything even closely resembling an emergency, just a normal, if sudden, traffic event. And the Posas court picked up on this, noting that in their case, if there was an emergency, the jaywalker, it was Posas, the lead driver, who faced it. Horton, the follower. She just faced the predictable result of her own tailgating when confronted with a routine hazard up ahead.
Right. And the conclusion in Templeton?
The court concluded the instruction should effectively never be given in an ordinary automobile accident case involving just sudden stops. They reversed the verdict. Giving the instruction was seen as misleading the jury about how much anticipation is actually required from drivers today.
That distinction is everything then. Routine hazard versus something truly, truly weird. Let's make this really stick. Imagine this. You're driving perfectly, safe distance, paying attention. Suddenly, there's this awful screeching sound from above. A huge landing wheel shears off an unmarked cargo plane flying overhead, smashes into the car in front of you, and bounces directly into your lane. Huge piece of metal. You instinctively swerve to avoid getting hit by this plane wheel, and you end up hitting a legally parked car. Does the sudden emergency doctrine apply to you?
Yes, absolutely yes. That scenario, that's the textbook definition of an extraordinary event. It's completely, utterly unforeseeable. You are absolutely not expected to anticipate airplane parts falling from the sky while you're driving. It's worlds apart from a sudden stop or a jaywalker. And crucially, 1, you were driving carefully beforehand, safe distance. 2, the emergency directly affected you. 3, you didn't cause the plane wheel to fall.
Yeah.
That is the very narrow, specific kind of situation where the doctrine is meant to shield someone from liability for that split-second life or death decision made under incredible duress.
Okay, so the bar is incredibly high. It sounds like courts are, well, extremely unwilling to apply this doctrine. So for the listener who's trying to get a handle on this, maybe for an exam or just understanding liability, based on Posas and Templeton, how should you break down a negligence problem if someone claims sudden emergency?
Right, you definitely need a clear checklist because it's such a narrow defense. If the facts even hint at an emergency, you have to run these checks in order. Okay, first, check prior negligence. This is the Horton test. Was the person asking for the instruction put in danger partly because of their own earlier carelessness? Were they speeding, following too close, texting, anything like that? Yes, stop right there. The doctrine is out. Done. Second, check the nature of the emergency. This is the Templeton test. Assuming no prior negligence, was the event genuinely extraordinary, like that falling plane wheel or maybe bridge suddenly collapsing? Or was it just a standard, albeit sudden, traffic hazard, a sudden stop, a jaywalker, car cutting you off? If it's routine, the doctrine fails. And third, check the affected party. Did the emergency truly confront the person asking for the instruction? Or did it mainly affect someone else, like Posas, the driver in front dealing with the jaywalker? And the person asking for the instruction only got into trouble because their bad driving, like Horton's tailgating, made them unable to cope with the downstream effects. If the emergency wasn't really theirs to react to initially, the instruction is improper.
Got it. So this deep dive makes it pretty clear. That whole "I couldn't help it" excuse. It's almost never going to fly in modern car accident law. unless you were faced with something truly bizarre, like, falling plane parts. The law expects you to be driving defensively enough to handle the normal, everyday chaos of the road. That includes the car in front of you stopping suddenly. Okay, so here's a final thought for you to chew on. If the law pretty much expects us to anticipate almost all ordinary sudden events, jaywalkers, sudden stops, kids in the road, what's the real policy reason for even keeping the sudden emergency doctrine around? Even for those super rare, extraordinary events, wouldn't it just be simpler, maybe fairer to stick to the one standard? What would a reasonably prudent person do? Period. Think about that standard. And who the law is ultimately trying to protect when things